Hi, everybody. This is Mark White, Dennis Fernandez of White Summers in the offices of Whitespace, our business affiliate. We're continuing our discussion with Dennis Fernandez. And Dennis, I think now is the time to talk about the new world in which we live with innovation and the patent law. So, in our last discussion, we were talking about your business as an innovation company, prosecuting your own innovation, and some of the lessons to be learned from that for emerging growth companies. But the law has changed in the past year. So what was it before? What's changed now? And let's start there, and we can decide where to go with our discussion.
Sure. There are different fronts where the changing is noticeable. I think one of the most noticeable areas is how the U.S. Patent Office examination has done much to improve quality and turnaround. So the review of cases includes not just claim analysis, but the specifications in a significant way. So the quality of patent examination, I think, is faster, and I think
So the fundamental
tougher.
law hasn't changed. It's really just the review by patent examiners.
Yeah,
And the scrutiny and attention they're giving to new patent applications.
That's right.
Okay.
I think a lot of the the problems that affected the perception of patents in this country has had more to do with marginal examination that went on for a window of years. But it seems that quality issue has been managed dramatically now. So I think that alone probably would have fixed the problem. There are other changes. For example, the federal courts, the U.S. Supreme Court has taken an aggressive position to question the patentability of certain technologies. All kinds of software, maybe all software, is vulnerable to being rejected as non-patentable subject matter, period. Whether or not it's inventive or not. Maybe you can't patent software in this country.
Now you're saying maybe, so this is evolutionary and dynamic. Okay, so let's take that. So most of the companies that we work with, or a large majority of them, are software-based solution companies. And there's different aspects of innovation that you may want to protect based on software. Are you saying software as a enabling system to a solution is, and filing a patent on that is no longer a good idea?
It's harder. So the practitioners like myself who understand the software technology and these changes in the patent law have found a different approach to persuade the patent examiners that we still are statutory, because we're not claiming an algorithm or a business method or some kind of online transaction in cyberspace, but rather an apparatus that transforms physically a machine from one state to a new state that is not obvious. So this shift in the legal practice has changed the way we secure protection for software automated solutions. But it's harder. I do think that you can still get protection on software solutions, but it's especially difficult for pure e-commerce companies or pure genomic data companies. I think that was a consistent policy message that was implicit in some of the recent Supreme Court decisions in Alice and Bilski and they really did not want the US patent protection to be used to create monopolies for pure software concepts.
So we're talking, Dennis, about how to protect business methodology and process, if that's possible in today's world, and then algorithms. So on business process, clearly in the past, many companies felt that they could protect this. There were patents filed on it. There were certain requirements that a business methodology be implemented before a system solution. What's the reality today on is a business methodology approach and a process protectable or not? And if it is, how is it protectable, and what would you do to implement this?
Yes. I think it's safe to say that if your invention is claimed only as the business method, purely a transactional process, that is almost certainly going to be thrown out of the patent office. So the approach that will remedy that problem is to combine aspects of that into the technology. Maybe the hardware for a more secure system, higher performance multimedia transmission, maybe a collaborative environment that allows for a rich media platform where the technology is woven into the business method. So you can have protection on the business method in the context of some interesting hardware or technology. So the combination, if the patent attorney is thinking carefully through this minefield, should be protectable, okay? I've tried it and it works, but it's really hard because the examiners can often see what you're trying to do, and so you have to negotiate. And this ends up, unfortunately, I think, narrowing the claims more than you need to, but you'll get the protection as implemented in these machines. Okay?
So the question then becomes, before we get to algorithms, are those types of patents assailable? I would think so. So you can get the patent, you can attempt to narrow the claims. Is it worthwhile?
Sure, it is. There are not too many narrow embodiments that you would narrow toward, like smartphones, laptops, maybe Internet of Things devices. So yeah, you just list the different scenarios where you would embed this code, whether it's a business method or even an algorithm. In a machine, you just have to describe each machine as a separately patentable device. Yeah.
Okay. Algorithms. Different type of innovation drives analytics, predictive solutions, filtering of data. So it's key to many, to the business platform for many companies. How do you protect that?
Yeah, this is actually one of the earliest areas where the federal courts and the US Supreme Court attacked the non-statutory subject matter, binary coded decimal conversion algorithms, stuff like that were tested like 30 years ago. You do the same thing. You argue that it's a digital signal processor chip, DSP, or you argue that the algorithm is really a computational logic device, okay, that is configured in silicon. So you may shift the attention away from the law of nature or mathematical algorithm space into the physical implementation. But you have to do this deliberately. You can't just blindly go in there and use, algorithm and words like that, those will spark immediate examiner attention.
Right, and so trade secret, copyright really wouldn't pertain, but trade secret, really if you're to look at the array, the arsenal of intellectual property rights and registrations that you may want to apply, patent is really the only one for methodology. And I mean, methodology becomes public, right, because it's how companies actually conduct business. Algorithms isn't public. You can keep that private, so a trade secret might make sense in that context. What do most companies do?
Well, some companies that are purely analytical, they get data, they analyze it, and then they come up with a report that's automated by a computer, they have a problem. You know, doing biomedical analysis based on genetic data to come up with a diagnostic report is highly algorithmic. Or, you know, processing information from molecules or science and not doing anything beyond computational analysis is going to be a problem. So there's a lot of companies like that that are very valuable but are difficult to protect. You need to have physical transformation, maybe in the factory where you automate and improve yield, something that maybe improves the combustion of an of a hybrid electric car, where there is a physical transformation of the mechanical devices. U.S. Supreme Court is going old school on this non-statutory subject matter issue. They want to see a machine that runs better. And saying that the computer runs better because it's running a better algorithm doesn't count in their eyes.
So this may be a unfair takeaway, but it would seem to me that for an early stage company, if it's a device company, where there's a physicality to the solution, if you're going to patent anything, that might be it. If you're a software company, maybe it's better to hold off on patent thinking and sort of taking preventive steps on spending money if resources are dear and you don't have it, because the likelihood of successful prosecution and issuance of a patent and then protectability is not as great as the effort going into it. Is that an unfair conclusion?
I think it's a very reasonable analysis. I would still file a patent, not because I'm biased as a patent practitioner, but what else are you going to do? I mean, you rely on copyright law, maybe on the actual literal code, or keep it as a secret for as long as you can, maybe. I think you're going to need to try to file a patent one way or another, and just couch it in the context of some physicality that is transformative, because even just static physicality is not enough. It needs to transform. They're looking for industrial innovation that makes something better from one early state to a later state. The transformation of the machine using technology is the industry that I think the Supreme Court is protecting based on Article 1, Section 8 of the U.S. Constitution about innovation as a protectable subject matter.
Okay, let's leave our conversation there. Gives us a taste of sort of the world in which we live now. Thank you all for being part of our discussion. We'll talk to you next time.